Hello, good evening, everyone. Happy Sunday and happy last day of the training because today is going to mark the end of the 1 month training we started from the 1 month training we started and we have been on since this month. So today we are finally coming to the end of the training on alternative dispute resolution. And I must tell you that you have been so committed, so dedicated. It has been a wonderful time, a wonderful experience here, and we really appreciate you. We thank you for your participation. We thank you for your commitment. We thank you for your dedication. It has been awesome. It has been wonderful. And I must say, kudos to you for being committed to this meeting to the very end. For those of you that have been joining consistently, we appreciate you. When we started, initially people joined like up to 100 plus, but as time progresses, the the, the number reduces. But many of you persisted until you are at this point of the training, which is the last day of the training. So it has been a wonderful journey, and we really appreciate your dedication and commitment and all the things that have been achieved over the course of the training is achieved because you committed yourself to be part of it. If you have not committed to yourself to be part of it, maybe I may not probably be here every day connecting to offer lessons. Maybe I will be doing something else. But you people have been doing this. So we really appreciate all of you and thank you for your participation from the very beginning to the last day of this training. And as for many of you that will be willing to take peace and sustainable development, you can as well register and participate in it as well. And the training will start on the 1st of uh, October. So do wait to be part of the meeting. We really appreciate you and we hope that at the end of it all, the knowledge you acquire here will not be a waste. Even if you're not going to use to apply for any job, whatever you are doing now, make the knowledge you acquired add value to what you are doing now. Do you understand? You may not necessarily use it to look for a job, but the knowledge you get here can add value to what you are doing. So make the value, the lessons, the knowledge here not to be in vain. Just apply it in your own personal life, in your family, in your local organizations, in your community engagement, in your organization, in your business. And I can tell you that you will go far. You will go far in resolving differences in business. So that's what it means. So I really appreciate all of you for your commitment and dedication. So we have successfully we created 4 groups, or rather, let me say we created 40 groups, and we have shared about 40 topics on simulations, some on arbitration, some mediation, some negotiation, some conciliation. People are still asking to be added in a group. People are still willing to join. Some of them don't have groups. We'll look into it. We are wondering how we are going to manage all this group, but let's see how it goes because peace and sustainable development, we may not have a simulation training. So let's take the time during this training to be doing our simulation because it's not during the time of the training that we're doing it. We'll do it around 4 p.m. to 6. so that even those of you that are working can still participate. Do you understand? So that's what it means. But you people have created your own groups to just coordinate your affairs and reason together and then prepare for the show. So prepare well so that you can be part of the show. And if you are part of a group, contribute to the maximum. Don't wait for others to do it and then you just there like that. So you too contribute to make that happen. Do you understand? So that's what it means. So we expect that everybody will participate in their various group actively, because when it comes to presentation, I want to see everybody doing something. If are not doing anything, I will ask you a question why you are not doing anything, because you must contribute. Do you understand? So that's what it is. So someone was asking the group after everything, how what are they going to do? Uh, you are going to come and present it, of course. Prepare in your group. When you prepare finish, you come and present it when you have an appointment during our peace clinic. Do you understand? So it's peace clinic is another avenue we educate people, and of course, what you are doing will be good to educate people. Do you understand? So that's what it is. So thank you very much for joining us today. Today is our last class on alternative dispute resolution. Alternative dispute resolution is one of the professional diploma courses being provided uh, by the Institute of Global Peace and Conflict Management for her followers on Facebook and on YouTube. So if you are not a follower on Facebook, if you're not a subscriber of the YouTube account, just do it, because several other benefits will be coming your way as we progress. Do you understand? So we'll grow to a point whereby we'll be giving people scholarships to go and do certain training somewhere outside Nigeria or in some other African countries. We can move you from your country maybe to Nigeria to come and attend a particular program. We can move you. So kind of benefits will be coming, and most especially for those that will be members of the institute. So try as much as possible to connect on all our social medias so that you can get some of the opportunities that will be coming up subsequently as we progress as an institute. All right. So thank you very much, and we appreciate you for connecting. Today we're going to look at the legal frameworks governing ADR. The legal frameworks governing what? ADR, because there are some legal frameworks that govern the operation of the ADR. Because, like we said before, if it's arbitration, it has to, in line with the legal provision so that it can be easily enforced. Because if it is not in line with the legal provisions governing the ADR, then it will be very, very difficult to enforce. Do you understand? So that's why we say that you need to know some of those legal frameworks governing the ADR so that you can be able to, take an effective decision as an arbitrator. Do you understand? So that's what it means. So for this legal framework governing the ADR, we'll be looking at understanding ADR registrations, that is overview of relevant laws and regulations. Do you understand? We'll also look at the enforceability of ADR agreements, that's key legal principles affecting arbitration and mediation agreements. Do you understand? So we're looking at the enforceability of ADR agreements, key legal principles affecting arbitration and mediation agreements. Then lastly, we'll be looking at judicial reviews of ADR outcomes. Judicial review of what? ADR outcomes, limitations and procedures for challenging arbitration awards. So these are the things I will be looking at for today or for tonight. So at the end of the day, we believe that it will be a worthwhile experience to be part of the training. So it's true to say that there are legal frameworks governing the ADR practices globally. Do you understand? in different countries. Even in Nigeria, we have different legal provisions that govern the practice of ADR. So, and in other countries as well, and other international organizations, um, professional bodies, bringing different governing principles or laws that help in governing the operation and the practice of ADR. So we'll be looking at some of them, um, both outside Nigeria and some of them in Nigeria. So you just follow so that you know some, most especially uh, the international ones that somehow, whether you are in Nigeria or you are somewhere else, you can still apply. And then the ones that are from Nigeria, you also know those provisions and those laws governing the ADR practices. Do you understand? So we say that alternative dispute resolution legislation encompasses a range of laws and regulations designed to facilitate the resolution of disputes outside the traditional court system. All right. So we're going to see an overview of relevant laws and regulations available. So one of them, we have the federal and the state legislations. Do you understand? We have the federal and the state legislations for many countries that practice democracy. Do you understand? Uh, and of course, you are maybe practicing federalism. You have states. Some of you have what we call the county. It's equivalent of state. Do you understand? Or equivalent of local government. Also, so it means in other places. So we have several of those legislations at the state level and at the federal levels. Do you understand? So in United States, for instance, the Federal Arbitration Act, the Federal What Arbitration Act, that is FAA, is a key piece of legislation that provides the legal frameworks for arbitration agreements and enforces arbitration awards. Okay, so based on this legislation, the awards are made to be enforceable. So whatever award you are giving must be in line with the provisions of this act. You understand? So that's what it means. So many states have their own arbitration status that complements the FR, that is in United States of America. Do you understand? So that's what it means. In UK, the Arbitration Act 1996 governs arbitration in England, that is Wales and Northern Ireland, providing a comprehensive framework for the arbitration process. So you can see, so the United States, the United Kingdom, you understand? The United Kingdom covers England, Wales, and what? The Northern Ireland. So I don't know about Scotland, but I think it's the same thing. You understand? But I think this is how it covers. And you can see in one of our meetings, we give one of the case studies how conflict was being resolved through arbitration in Ireland, Northern Ireland. Do you understand? So you can refer to those case studies to see what it means. So number two, we have international treaties and conventions. That is, apart from the ones we have in the United States, the United Kingdom, we have international treaties and conventions, all right, that provide some legal frameworks to govern the operation and the practice of ADR. Do you understand? So, and these are the ones that are being applied globally because they are international treaties and they are conventions. Do you understand? So, they are being applied, or they apply them globally. You can apply them everywhere. Do you understand? So far as your country is a member of, of the United Nations, do you understand? You can use it. And we have the UNCITRAL model law on international commercial arbitration. Do you understand? So that's what it is. The UNCITRAL, all right? UNCITRAL model law on international commercial arbitration. That's the United Nations uh, Commission on what international trade and trade law. That's what it is. So on central, right? So it provides a framework for the conduct of arbitration proceedings and is widely adopted by the various countries. Countries that are member states of the United Nations adopt the provisions of these treaties and conventions. Do you understand? So that's what it is. So we talk about the New York Convention, the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. That is, this convention, basically, the job of this convention is to ensure that award giving anywhere in the world, that is international convention award, that is arbitral awards, are enforceable. So you can use the provisions of this convention to enforce whatever award that is award anywhere. Do you understand? So that is why we call it the New York Convention. Its job is to recognize and of course enforce. First they recognize the award given and of course enforce is provided is in line with the provisions of the ADR, the frameworks, the legal provisions governing the ADR practices. Do you understand? So if you are applying, you are basing your award on the provisions of the UNCITRAL, it's possible that they can easily be enforceable at the New York Convention. Do you understand? Or you can use the New York Conventions and make sure that your awards are in line with what the provisions there says, so that it can be enforced. Do you understand? So and it can be enforced globally. Then we have professional standards and code of conduct. We have professional standard and code of conduct. Of course, we have various professional organizations such as the American Arbitration Association and the Chartered Institute of Arbitrators. Do you understand? They have established rules and ethical guidelines that govern ADR practices. So you look at their guidelines, as of course, they will also help you in line with that. And so if you are a member of them, maybe with time, we also have our own. Do you understand? So you can use the institute own as well, and then see how you can use it globally. Or because we will make sure that it's not just enforceable in Nigeria, we will make sure that the principles are being accepted globally. Do you understand? So that's what it is. So professional standards and code of conduct. So once they defined and those guidelines are being provided, then it can guide practitioners to be able to have something to refer to and then give award and of course make those awards enforceable. Do you understand? So that's what it is. So we'll talk about judicial interpretations. Yes, there are some judicial interpretations or judicial precedents. Okay, courts often interpret ADR agreements and enforceability issues, right? So impacting how ADR is applied in practice. So judicial decisions can clarify the scope and limit of ADR processing. And of course, you can make reference to those interpretations. All right, you can make, once the interpretation is given, it becomes a precedent. Do you understand that you can follow? Do you understand? So those precedents and those interpretations can be made reference to, and of course, make your case to be enforceable. Do you understand? So that's what it means. Then we have the consumer protection laws. We have the consumer protection laws. Okay, so some jurisdictions have specific regulations that limit the use of arbitration clauses in consumer contracts, ensuring the consumer have access to judicial remedies in case uh, you go and consume what you don't want. you know you go and remedy yourself somewhere. uh, so it may not be just the issue of ADR alone, but there are provisions so that you can even seek remedies in the court of law. Okay, but there are some countries that open up for arbitration or for the ADR for it to be conducted and settled at that level. Do you understand? So we have those consumer protection laws available that govern the operation of the ADR. We have registration on mediation. Registration on what? Mediation. Certain jurisdictions have enacted specific mediation status that set out procedures and standards for mediators, ensuring a structured approach to mediation. So For those of you that will be acting as mediators, you have to ransack, right, so that you can be able to perform well in your simulation. You arbitrators as well. So, like I said yesterday, it's not if your topic is on if your topic is on conciliation, do you understand? Then those people who co-arbitrators in their group, they are not arbitrators, but they are conciliators. If your topic is on arbitration, then those people referred to as arbitrators in the group assigned to you will remain arbitrators. Do you understand? If you if your groups if your topic is on negotiation, then those we call arbitrators will become what, negotiators, and of course it applies to uh, mediation as well. They become mediators. So don't just say that. Don't come and say you are working on a topic that has to do with mediation, and then you come and say arbitrators who cancel it. Will give you zero. So if you're working on a topic and your topic is mediation, those in C that will say the arbitrators are what, negotiators or mediators or conciliators or arbitrators, as the case may be, depends on the topic you are working on. So, and I think I specify it clearly. Group one to group 1 to 10, I think it's on mediation. Group 11 to 20 is on arbitration. Group 21 to 30 is on negotiation, and then group 31 to 40 is on conciliation. So know this and don't make mistakes. Do you understand? So that is it. So registration on mediation. So you have to look at, we have also registration that govern mediation. We have confidentiality and privilege. Many ADR statutes include provisions that protect the confidentiality of the proceedings. All right. So ensuring the discussions and documents remain private. So privacy is also a concern, and it has provisions that govern confidentiality as well. Do you understand? So as ADR practitioners, you have to look into all of these issues and legal provisions that govern this aspect that we have mentioned. All right, but let's look at some of the specific legal provisions in Nigerian context. Do you understand? Let's look at some of those provisions, legal provisions, and that govern ADR operation in Nigeria, because we are here in Nigeria. So let's look at some of those provisions. You can choose to look at some of those provisions in your country. For those of you that join us from other African states or African countries, other nations like India, as well, we have a participant from India. You can choose to research on the registration governing ADR in your country. Do you understand? Because most of us will be practicing in our countries. So you check what is obtainable in your own country, so that you can apply it in your own place. Do you understand? And of course, we have those ones that are globally used, and we have told you about them. We have the International Chamber of Commerce. We have the Central. We have the New York Convention. This one can be applied globally. Do you understand? So of course you can still use those ones. So far as where you are, your country is a member state of the United Nations, you can apply it. Do you understand? So and then but let's look at some of the legal provisions in Nigeria. We have Arbitration and Conciliation Act. That's ACA. What? ACA. Arbitration and Conciliation Act of 1988. Do you understand? It provides the legal framework for what arbitration and conciliation in Nigeria. So those of you that your topic is under conciliation, on arbitration, you can check. You can try to bring your own. Those of you that are also from other countries, you can check and add value in your group. You can bring what is obtainable in your place. And those from Nigeria can also bring what's obtainable in their places. So you go and do a research and get those information so that it can help you in your word assimilation very well. You understand? So it aligns with the uncentral. You get it right. It aligns with what is obtainable what internationally, uncentral what model law, and outlines the procedure for conducting arbitration, including the appointment of arbitrators, conduct of proceedings, and enforcement of arbitral awards. So it's like what is obtainable at the United Nations is what is applicable globally. So many countries develop their own provisions in line with the provisions obtainable at the United Nations. So it make it easier for awards to be enforced globally. Do you understand? So that's what it is. So that's why all the member states of the United Nations if you can obtain something similar, what is obtainable in countries that are members of the United Nations, you may have something similar. Do you understand? Something similar because what is at the United Nations is a standard within which every country is developing their own provisions. Do you understand? So you have it at the back of your mind. So in case you don't want to use the one in your own country, use the one at the United Nations. There's no problem. Do you understand? We see consider it acceptable. And then we have the Nigerian Evidence Act. Nigerian Evidence Act, how to present evidence. They will have provisions that govern how to even present evidence. Do you understand? Evidence Act. So certain provisions in the Evidence Act addresses confidentiality and the admissibility of evidence in ADR proceedings, particularly regarding the protection of statements made during mediation. Protection of statement made what during mediation, so that you cannot go and be outside with it. Right? So we also have Investment and Securities Act. Investment and what Securities Act, that the ISA. The ISA includes provisions for the resolution of disputes arising from what investment transactions, often encouraging arbitration as a preferred method of dispute resolution. So you make a business investment, all right, whether with Nigerian Security and Exchange Commission or whatever, you should understand what it means. So if there's any challenge, you understand, you can go there and settle the matter. Yeah, or bank eat your money. Money disappear in your account. Just we have sometimes we have issues. We have money will just disappear, and then they say that you compromise your PIN. Sometimes you don't even have a TM card for that. You don't even have a mobile app for your account, and then money disappears. So how can you say that somebody compromise? You don't understand information. So these are some of the issues. So in that kind of situation, Investment and Securities Act will help you to mediate effectively. Do you understand? Then we have National Industrial Code Act. National Industrial Code Act. That's if the matter has to do with labor issues, job related issues, you are sacked, you know, unconstitutionally. I think there's one of the Chief Justice of the Federation that was sacked at some point, Zero Naogan or whatever. He's still in court. I think court has given them I think the Supreme Court give them the opportunity to go and resolve with the federal government outside of the court. I think something like that. I think I heard something like that, or I read something like that. You understand? So uh, they said they should go and use arbitration or mediation or whatever to settle that matter because the man said I was sacked, you know, illegally. So I need to be compensated. So whatever they resolve with the federal government, maybe they will tell us later, or they may just enter voicemails as usual. And maybe they will give him plenty money so that he will go and sit down and enjoy his life. You understand? So that's what it is. So, but we have National Industrial Code Act. So the act establishes the National Industrial Code of Nigeria, which has jurisdiction over labor and employment disputes. You understand? So it encourages the use of ADR methods such as mediation and negotiation to resolve such dispute. So for those of you that your topic has to do with labor issue, bear in mind, oh, if you are bringing some kind of uh, work to present at the peace clinic, and your topic related to work, to labor, to employment, refer to this act, go and check it. National Industrial Code Act. Please, so and that's the reason why I'm presenting this topic as the last topic, so that it can help you in preparing for your peace clinic and simulation. Do you understand? So if you have a topic that is related to this, some of these acts I have just mentioned, please cite them. Cite them in your conversation. Go and make research on them. I'm giving you what I'm giving you is a head point. Do you understand? I'm giving you a direction to follow. All right, that's why I'm pointing them out, so that it can be easy for you to research. All right, it can be easy for you to research them and see what they have said. You understand what is contained there. So please do way to research and apply them in your discussions. All right. All right. Let's proceed. So in Nigeria, we also have Consumer Protection Council Act. Consumer Protection Council Act. The act promotes the use of what ADR in resolving dispute between consumers and service providers. Resolving dispute between what consumers and service providers. Ensuring accessible avenue for consumer redress. You go and buy something and the thing is not good, and maybe you went there to refer, maybe for a kind of exchange, and then they say no, since you have taken it away, we gave you, it was intact, nothing spoiled. Yeah, maybe you are the one that spoiled it. So dispute has arrived. So you look for a way to report and see how it can be resolved through what negotiations or arbitration or whatever. Do you understand? That's it. And this provision will guide you. So those of you that your topic is under consumer protection, take note to. Uh-huh. Let's move forward. The Nigerian Bar Association NBA guidelines. For those of you that are barristers in the house, maybe you can agree with what we are saying here. The NBA has developed guidelines and code of conduct for mediators and arbitrators, promoting best practices in ADR processes. Am I lying? For those of you that are lawyers, am I lying? I know some, we have lawyers here. If I don't know many, I know Ambassador Harima. So Ambassador Harima, am I lying? If I'm lying, you let me know. But that is what it is. So we have Nigerian Bar Association and guidelines. All right, they provide them those guidelines to help you in carrying out ADR practices. Then we have the Lagos State Arbitration Law, the Lagos State Arbitration Law 2019. This one is even of recent. Do you understand? So this law provides a modern framework for arbitration in Lagos State. That's what we told you, federal and state. So some of these ones that we have mentioned here are federal, like the Consumer Protection Council Act, the Arbitration and Conciliation Act. All of those things are federal. Do you understand? The NBA now is a professional organization. Do you understand? It's a professional association. I think we mentioned something like that before. Okay, so just give you one example of those professional associations. The NBA. You understand? I even mentioned one in America. All right, and then we have the Lagos own now, the state own, because we say some of these things are being provided by the states. Do you understand? So we have the Lagos state taking a lead in that direction. Do you understand? So that's what it means. So this law provides what a modern framework for uh, arbitration in Lagos State, promoting the use of arbitration and mediation in resolving commercial disputes. Commercial what dispute? So if you're in Lagos State, you're doing business in Lagos State, and there is a commercial dispute, you can seek the Lagos State Arbitration Law to resolve your matter in Lagos State. Do you understand? In Lagos State. Don't, I'm talking about jurisdiction, do you understand? So don't, something Lagos and Ogun State and say, the enabling state. No, it's in Lagos State. So if it's within the jurisdiction, it can easily be enforced. But when it's outside of the jurisdiction, then it becomes very, very difficult to enforce. Do you understand? That's one thing with arbitration. So are we together? So I hope we are following up. So Nigeria's legal framework for ADR is continually evolving. Of course, they have to evolve over time. All right. So that's what it means. So they are evolving. All right. So I don't know whether we are following. Out together. Can you hear me? Hello, can you hear me? Hello. Can you hear me? If you can hear me, let me know, please. If you can hear me, let me know, please. Good evening. I apologize. My system hang, so I have to dismantle it, couple it, and reboot it. So it takes a time to reboot. So that's what happened. We apologize for the technical issues. Um, I just hope that the institute will buy me a new laptop so that we'll not be having technical challenges. I believe the institute will do something in that regard so that we can have our lessons seamlessly. You know, this is just a technical hitches, but I believe that the institute will make provisions for us so that we can continue to have our meetings without hitches. Thank you very much for staying put to be part of the training to the end. For those that may not wait, it's good to be patient. And one of the characteristics of a peace ambassador is patience. So if you are not patient enough, you cannot be. Do you understand? So for you to be able to resolve conflicts effectively is when you are patient. So thank you for being patient enough to wait and for us to come back to solve the problem. I saw someone saying just wait a day, right? Always wait. Don't rush to quit. Always wait. You never can tell. All right. So but thank God we are back. So let's move forward. Let's move forward. Let's move forward. So we are going to look at ability of alternative dispute resolution, right? And we are looking at that is the enforceability of the alternative dispute resolution agreement. Do you understand? And then we are going to look at specifically arbitration and mediation, right? Agreement, how they are be enforced, the factors that influence, key legal principles. So we are going to look at those factors affecting enforceability, all right, of mediation and arbitration awards. So one of those things is one of the factors that is affecting the enforceability of arbitration or ADR awards is consent, consent, consent. So in ADR, there's something we say these things are being done voluntarily. You're not forced anybody. So you have to obtain the consent of both parties involved. So we're talking about mutual agreement. Mutual agreement. All right. Both parties must voluntarily agree to the ADR process. So the agreement should clearly outline the terms and conditions, including the scope of dispute covered. Do you understand? So before you proceed, there must be a mutual consent. Please, in your simulation, though we are doing just to practice the skills, do you understand what we have learned? And so try to be as formal as possible. I would say these things are based on mutual consent. So before you start the process, let all the parties agree to the particular thing that you are working on. Do you understand? Okay, agree for mediation. Maybe that's the topic we are working on. So all the parties involved should agree, right? And then you outlines the procedures, the ground rules, and all of that. Do you understand? And then from there you proceed in the discussion of the issue of consent. Do you understand? All right. So mutual agreement, capacity to contract. All right. So parties must have the legal capacity. That is, it, you cannot ask a lunatic to come and be a party to anything. neither could you ask a minor to come and be a party. So the parties must have the capacity to contract. Do you understand? So, and then we talk about written requirement, written requirement. So many jurisdictions, including under the Federal Arbitration Act in the US and the Arbitration and Conciliation Act in Nigeria, requires that arbitration agreement be written, be in a written form to be enforceable. So you cannot just give a award just verbally. All right, it's not possible. You have to. It has to be in a written format. Do you understand? It must be in a written format. So of course, whatever you people are going to do in your simulation at the end of the day, okay, because you are going to work it. So you are just coming to demonstrate how it's being done. Do you understand? At the end of the day, you read the award from what you have resolved. Do you understand? You read the award or what you have arrived at. So this thing should be can be documented, right? It can be documented. It's possible. Just prepare something, and then maybe you can go through it, and then in a process, just negotiate in such a way, guide in such a way that so after at the end of it all, you write. Hmm. You write, all right, so that it can be enforceable. That's fine. Then clarity and specificity, all right. So it should be clear and it should be specific, all right. The terms of the ADR agreement must be clear and specific, all right, to the nature of the dispute. You cannot go and generalize issues. No, no generalization. Let it be specific to the matter you are working on. Do you understand? Then public policy, ADR agreement must not contravene what public policies, right? So court may refuse to enforce agreement that limit access to justice or violate statutory rights, all right, such as consumer protection law. So if your award contravene any public policy or law, it will not be enforced. So that's why we say you should give your award in line with the provisions of the law, what the law says. And that's why we say you must have knowledge of the law as well, what the law says. So if you're working on a matter that has to do with consumer protection, it has to do with uh, employment or labor, you should be able to consult some of these provisions for your award to be enforceable. Do you understand? So you can say according to so act provision cap so subsection so whatever. Do you understand? Or subsection A or B, and then based on these legal provisions, we have award this. Do you understand? I think you should be able to demonstrate something like that for it to be acceptable. All right. So then we talk about unconscientiability. Unconscientiability also is something that you have to consider. Courts may refuse to enforce ADR agreements that are deemed unconscientiable. That is, an agreement may be considered unconscientiable if it is excessively one-sided. One-sided. If it's excessively one-sided, that is, if the award does not benefit both parties in some way, that is heavily one person is just favored, then court may lightly refuse to enforce it. Do you understand? So, or if one party had significant more influence or bargaining power, do you understand? Court may refuse to enforce such. But wait a bit. When it comes to international trade, do what is saying here, although they say may, of course it may be enforced, it may not be enforced. Do you understand? So because I, I can see some of the implementations. If for instance now let's look at the country level. Nigeria negotiating with America or UK. Do you see that? you can see that the bargaining power of America or UK is much more than that of Nigeria. Because if you look at it critically, some people that sometimes, most of the times involved in these things have no knowledge of what is involved. So an element of inferiority complex also are always there. Do you understand? So, but these are the issues. So then I will talk about non-interference by courts. So courts generally respect the autonomy of parties to resolve their dispute through what? Through ADR. So courts generally they favor ADR, alternative dispute resolution. And that's why in most cases some courts will ask you, have you made effort to resolve this and it didn't work? Do you understand? They want to know whether you went through ADR processes and it didn't work. And I think we should step it up to make sure that these things are being considered before any other matter. Do you understand? Before court, we accept to admit a litigation for any accept any litigation or lawsuit for a case. Do you understand? Before you accept it, ask questions. Have you tried all those processes and they didn't work? So that's why one of our member, an inductee in the last Abuja induction, was agitating that the judicial council should review some of these things and make sure that before they admit any matter in the court, let certificate of what? Certificate of let their ADR certification should be given, ADR certification to show that okay, this person has tried all mediation or alternative dispute resolution mechanism and it didn't work. So we allow him to proceed to court. Do you understand? So let people show that certificate before a case will be admissible in court. So if we can have something like that, it's going to help much more to address some of the problems we have, whereby the court is overloaded with cases, and then they attend to political cases because those ones they are faster, and leave others, and then people continue to suffer in jail. This is one of the aspects that the Justice Forum is going to address seriously. The Justice Forum of the Institute are going to address so that people will not just end up suffering in jail endlessly. There must be an end to some of those things. Do you understand? As much as possible. So, enforceable of arbitral awards. Enforceable of what? Arbitral awards. So, arbitral awards resulting from a valid arbitration agreement are generally enforceable. Okay, under the New York Convention and domestic arbitration laws. To arbitral award resulting from a valid arbitration agreement are what generally enforceable under the New York Convention and domestic laws are the ones provided by the Arbitration and Conciliation Act 1988 in Nigeria are also enforced. Do you understand? So once it's followed the process, it's enforceable. Do you understand? Confidentiality. Confidentiality provisions in ADR agreement enhance their enforceability. Parties are often more willing to engage in ADR if they know that the proceeding will remain private. The proceeding will remain what? Private. So privacy and secrecy is a matter of concern so far as ADR issues are concerned. So far as parties have the confidence in the proceeding that well, it's going to remain as confidential and as much private as possible, then they will put into it. Do you understand? They will welcome such. So lastly, let's look at judicial review of outcomes from alternative dispute resolution. Okay, what are the judicial reviews of outcomes? Is it possible? Can it be done? Are there challenges? Okay, and there are specific limitation and procedures for challenging arbitration award. Let's look at some of them. We say we have limited. Number one, we have limited grounds for challenge. That is, there are limited grounds for you to challenge arbitration award. Do you understand? Or ADR awards. There are limited chances for you to challenge. Because once the procedure is followed, it's very difficult for you to challenge it. It must be enforced. Do you understand? It must be enforced. So courts typically have limited grounds on which to review arbitration awards. Common grounds for challenging include lack of jurisdiction. That is the common ground. Lack of jurisdiction. If, like, okay, Lagos State arbitration law. So if the matter happen in Ogun and you want to go and enforce it in Lagos, practically impossible. Do you understand? So in this kind of case, there's the issue of jurisdiction. Do you understand? And so of course it can be challenged. It can be challenged. But if it's within Lagos and it's enforced in Lagos, then it's very, very hard for you to go and talk about the issue of jurisdiction in Lagos State when the matter happened in Lagos and it's under the Lagos law. So you cannot go and challenge arbitration award on the basis of jurisdiction. It's not possible. You understand? So we talk about procedural irregularities. Okay, this is another common ground where the processes or the procedural applications are not followed as, or the procedural principles are not followed as they are outlined. Then it's possible that you can challenge arbitral award based or ADR award based on these irregularities. Do you understand? It's possible. Then public policy. So if the award contravenes public policy or an act of the law that you know, you can be able to challenge the ADR award based on that provisions of the law. Do you understand? And then we'll talk about bias or misconduct in case there are any element or gray areas, bordering on misconduct or bias or tendency of favoritism or whatever. It can be challenged. It can be challenged. It can be challenged. Do you understand? Based on those areas. So, and these are the limited grounds that court can be able to welcome, you know, uh, any appeal or any challenge of arbitration award or ADR award. Do you understand? So have it at back of your mind. We mentioned those grounds that you can be able to challenge arbitration or ADR award. We talk about lack of jurisdiction, procedural irregularities, public policy. That is in case an award contravenes public policy, it can be, challenged. And then of course bias or misconduct are some of the areas by which you'll be able to appeal in arbitral award. Then we'll look at no re-examination of facts or law. No re-examination of facts or law. Courts do not re-evaluate the merits of the case or the factual finding of the arbitrators. Do you understand? Court do not re-evaluate what the law says. No. And of course, they also try to go with the factual findings. That is, if the findings are factual, you cannot ask the court to review them now, because this is what is factual. Mr. A does this, and he agreed that yes, he did it. So what do you want the court to review in this case? It's a fact. The fact is that the training was organized. The training was organized by the Institute of Global Peace and Conflict Management. It's a fact. The training was organized. So what do you want the court to review? Do you understand? So there are facts. So once these factual findings are provided, then there's no provisions for what review. You cannot ask the court to evaluate this. It's not possible. Or what the laws are saying. So the focus is primarily on procedural fairness and adherence to the arbitration agreement. All right. So time limits for challenges. So Most jurisdictions impose strict time limit for filing challenges toward arbitration awards. So, for example, under the Federal Arbitration Act in the US, a party must file a motion to vacate an award within 3 months of receiving it. So if within 3 months you are able to file, then it's possible that it will be welcome. But after the expiration of this period, if you try it, you will jam rock. Do you understand? You will jam rock because already the time has elapsed. And once the time elapsed, you cannot be able to challenge it. Do you understand? So you can do everything you can within the time specification to file your challenge. So filing procedures and challenges to arbitration award typically requires the filing of a motion in court with appropriate jurisdiction. With appropriate jurisdiction, do you understand? The court that has the capacity to adjudicate so far as the issue of geographical location is concerned. And so if you go and file a case in a matter where the court cannot be able to entertain based on the issue of jurisdiction, then of course it cannot be welcomed. Do you understand? It's become impossible to challenge. So the motion must clearly state the ground for the challenge and provide support evidence. All right. So burden of proof. So the burden of proof generally lies with the party challenging the award, because now if you come to challenge an award based on the issue of biases or misconduct, you must present an evidence. Do you understand? So and it will be very very hard for you to come with the evidence that you are you to defend an evidence such as proof and evidence such as bias. No, it's take so much effort to prove such. Do you understand? So it's a challenge. It's a burden. The burden of proof is also a challenge. So and in court, we expect you to have concrete evidence. It's not just something you just come and talk, then the court will hear you. No, in court, we want evidence. Evidence. All right. Show us evidence. All right. So that's it. So appeals. The possibility of appealing a court decision on arbitration award is also limited. Many jurisdictions restrict appeals to question of law or procedural issues rather than factual determinations. Understand? So once the court determines you cannot appeal, there may be limitations for your enforcement of award. So if a challenge is unsuccessful, courts typically enforce the arbitration award as per the New York Convention or relevant domestic law, reinforcing the finality of the arbitration. So if you make effort to challenge and those efforts fail, what is left for the court to do is to enforce the award. That is as simple as that. So judicial aptitude, judicial what attitude, judicial attitude, not aptitude, judicial attitude. Generally, court exhibit a pro arbitration stance. That is, it supports arbitration. So emphasizing the importance of upholding arbitration as a viable means of dispute resolution. So this approach limits judicial intervention and promote the finality of arbitration awards. Do you understand? Because if it's based on fact, if the findings are based on fact, already court is lenient with arbitration. Do you understand? That is, it supports what arbitration arrive at. If it's look at and discover that there's no much issue here, what we say, what the arbitration say actually is factual. So you cannot change anything. Let it be. Do you understand? So let it be. So judicial reviews of ADR outcomes, particular arbitration, is designed to respect the autonomy of the arbitration process while providing limited avenues for challenge. Do you understand? So parties involved in arbitration should be aware of these limitations and procedures to navigate potential disputes effectively. So that's what is involved. So And that is much we are going to take today. I must say congratulations to you for striving hard to finish this race. You started the race and you are finishing. You are not just finishing, you finish strong. So the enemy did not want us to finish because of laptop issue, but thank God say the grace here passed the enemy, the power of the enemy. So we finish it. You understand? We finish it. So that is it. So thank you very much. We appreciate your participation and contribution. Do we have any question? Do we have any question? Do we have any questions? Any question? Any observation? Any question? Any observation? All right. Any question? Any observation? Any contribution? So, um, so I'm looking at it. When should we start our, most especially for those that are group A, group one, group one. I don't know, when are we ready to start our, presentations, our simulations presentations? When are we considering to start it? Um, I want you people to contribute. When are we going to start it? Should we start on Tuesday? Should we start on Tuesday? I want us to have a free day tomorrow so that you can take time to work on those things. So that on Tuesday we can start by 4 p.m. So, but I will still make those announcements in the group so that people can take them serious. And of course, our examination is going to be, 70%. And our simulation practices is going to be 30%. And then also, I want you people to do a testimonial video. Everybody should do it. I know some people don't do it. What does it take for you to say, oh, my name is so, and I enroll for a professional diploma in alternative dispute resolution, which was provided for free by the Institute of Global Peace and Conflict Management. And in the course of the training, I learned this, I learned this, and I learned this. And this is how I'm planning to use the skills I have learned. To do this short video of 2 minutes, 3 minutes, is too much? You're not asking for too much. We want to know what you know. We want to know what you learn. So it's one way. It's like you are giving us a feedback on what we have taught you. In a way, you are demonstrating what you know and giving us another feedback to know that, yes, we did not waste our time here. You learned something. So it is a way of telling us that, yes, you have learned something and we did not waste our time. So please do a testimonial video. Everybody should do it. It's individual, it's not group. Individual videos and send to us to help, because you have seen we have been sharing those videos on our platform, and that has encouraged others also to participate. So it's in one way of also creating awareness about the training so that people can take advantage of it. Our goal is to make society better. Do you understand? To add value, to impact lives. That is what we're doing. All right. So if you can do this, it will help. So do a testimonial video and send to us. So I'll be expecting those videos to start coming in by tomorrow. So that's it. Make sure that you sit in a very clear place, that a brighter place, so that you can do a clean video. The video should not be blurred. Do you understand? So that's number one. So another thing is so your examination is going to be next week, That is this week, Saturday. Saturday, all right? Examination is going to be on Saturday. I will try as much as possible to study up the manual so that I'll send to you today or latest tomorrow. So you get your manual, start reading, okay, and preparing just to go through it and then prepare for your exams. All right. We may not set up to 100 questions. We may set like maybe 25 or 50 questions or 30 or 35 questions. 35 questions, and we are setting 35 questions. So each question will carry 2 marks. So that is 70, right? So if you are able to get, if you are able to get 40, if you are able to get 40 or 30 in your exams and your group get 30, then you pass. You understand? So if you are able to get 20 and your group get 20, that's on your own person. If we get 20 in your exams and your group get 20, you fail because pass marks 50%. So if you get 30 in your simulation, no, you get 30 in your examination and you get maybe 20 in your simulation exercise, that is 50, you pass. Do you understand? So you have to do well so that you can get at least 30 to 40, in your exams, and then do well in your simulation at least to get up to 30, 25, 20 marks, all right? So that it will help you to pass. So you must try hard to do this. So for those of you that doesn't have groups, because yes, I'm talking that these people were saying, okay, what about those of us that doesn't have groups? Please drop your name in the WhatsApp group, in our WhatsApp ADR group. Don't chat me privately. Drop your name in the group there. We'll just look at your names, and then group you. Do you understand? Group you so that you can have a group to participate, because the participation is going to attract marks. So if you don't have a group, send your name in the WhatsApp group so that we can be able to identify you and give you a group so that you can participate and assign a topic for you. Do you understand? So try as much as possible to do that. Someone is saying that it's not in a group. If you're not in a group, we expected you to be in a group. All right. If you're not in a group, I don't know. If you're not in a group, check our website. Check our website www.igpcm.com.ng, and then give us okay, let me post our website. I'm sending our website in the comment. So you go to our website, you check our contact details. So you send me a chat that you are not in any group so that I will add you. But we expected that people should register for this training and join the WhatsApp group. So if you do not join WhatsApp group, that was a costly mistake. But if you're not in any group, try and be. So I have sent. So I'll post the link, our website. So check our website, check our contact. Or you take our contact on our Facebook account. Just yes, there are phone numbers there. So you can chat us there that you are not on any group, and we'll get to you and add you in the group. So in the WhatsApp group, so that you can participate in what is going on. So and the deadline for the simulation, people are asking the deadline for the simulation, right? And the deadlines for the simulation is I don't know. I don't know, because the truth of the matter is that we have 40 groups. 40 what? 40 groups. 40 groups. We have 40 groups. If we are going to use, and because most of you are workers, we cannot say we use morning time or afternoon time to do all of this until close of work. That is from 4 p.m. to 6 p.m. So we have so maybe we can be giving you, I don't know, if we say we give you 30 minutes, it may not be enough. So what we'll do is that we're going to we'll give you 1 hour. So we'll be taking two groups per day. Do you understand? Except people are saying that we should do it even after our training in the evening. We can still do the simulation. We can still do it. Do you understand? Maybe we can do it from 8:30 to 9:30, another 1 hour. So we can take 3 groups in a day, but it's going to be so demanding. Not for me, I'm not bothered. I can do it. I can comfortably do it. It's just about you. Do you understand? So um let's see how it goes. Here I will take 2 groups per day. So if I'm taking 2 groups per day, it means that we we will need, and more groups are coming. So maybe groups will reach like 50, because we are not going to have more than 6 in a group. Or we may decide to add the people to the existing groups, so that let's but the challenge is that we cannot bring people online more than 10. That is maximum. That's the maximum we can bring for live conversation. So if we have if we have 8 plus myself, maybe that is 9. Oh, and Janet will be joining us, of course. So if that is the case, 10. So that's maximum. So maybe we'll add 1% to each group. Let's see. So we know that we have 9 people to be on live chat. Do you understand? So um, instead of adding new groups, we'll add individuals and see one per each group. So if we have still people remaining, we'll still look at what we can do together. So that is it. So we may we may decide to add as many, but not everybody will join the live conversation. That is just it. You will delegate people to represent you and do it for you. You understand? So maybe that's what we'll do. Instead of adding any group, I don't want to add any groups because it will be demanding and it will take time for us to finish. It will take like October 20th for us to finish, or 20 something. So I don't want to I don't want us to I don't want us to add more groups. So we'll just add you people to the existing groups. Those that don't have group, we'll add you to existing groups so that you can contribute and be part of it. That's what we'll do. So thank you very much. Um, the topic somebody's asking, how do we know the topic to talk about? The topics are assigned. If you're in a WhatsApp group, the topic group 1 to 10 have their topics on mediation. Group 11 to 20, they have their topic on arbitration. Group 21 to 30, they have their topic on negotiation. And of course, group 31 to 40 have their topics on conciliation. So all of this has been posted in the group. Do you understand? In our WhatsApp group. So if you're not in our WhatsApp group, I give you our website. Go there, get our contact, send us a chat that you are not in any group, or you are not in our WhatsApp group at all, so that we'll add you there so that you can be part of what is going on. So that is it. So check, it's in the WhatsApp group. We posted them there. All right. Somebody's asking a question. Sir, is the WhatsApp group for next topic ready? I don't understand the question. What do you mean by that? Please clarify so that we'll know what you're asking. I don't know the question. All right, so that's the much we can take for today. If there are any other information, we'll tell you in the group so that you can. So somebody was asking, how do we, uh, somebody is asking the remaining manual. Somebody is asking the remaining manual, training manual. So we are going to send you the whole manual. Now it's going to carry out everything from A to Z. Do you understand? So you have one manual that covers everything. So forget about the first batch we send to you. We're going to send you a whole complete copy together now. So you can get it as a whole and then use it. All right. So that is how it is. So somebody was asking, where can we post the video? That is the testimonial video. The testimonial video should be sent to uh, the official glow line. That is official line, the glow line, the one that ends with that is the one that's is 08077987757. That is our glow line. So if you are an international student, you put plus two what +234 +234. Okay, let me just type the number here so that you can get it. +234 8077987757. So you can send your testimonial video to this number, to this line. All right, to this line. So I'm sending it. See the number there. You can take it from there and make use of it. That is the number you are going to send the video, the testimonial video. So you can go to our WhatsApp group and get the number there. It's also there. So you can use it to send your videos. Thank you very much. All right. See you. See you by, so group A, no, group 1, prepare for Tuesday. We are starting on the 1st of October. We are starting on the 1st of October. So by 4 p.m. group A, group 1 we present, group 2 we present. Group 1, that is group 1, you start 4 to 5. Group 2, 5 to 6. We will send you the link that you can use and join. You understand? So we'll get a group leader. So we'll send the links to you. You post it in your private WhatsApp group for your group so that your members will follow and join the conversation. Do you understand? So we'll send the link to you so that you can click on it and join. So make sure you are in a good network area to be able to connect. Do you understand? So that's it. So we'll send you the link. So group 1 and 2 prepare for Tuesday, starting on the 1st, so that we'll know that we have only 20 days to complete this conversation. And then you get your certificate. You must have finished your exams, but you must complete this thing before you get your certificate. So that's it. So thank you very much. See you by tomorrow. We'll still post some of these things in our WhatsApp group so that you get all the details. Thank you very much. I will still do a voice record and then send to the WhatsApp group so that this explanation will be done clearly. You understand? Thank you very much and see you on Tuesday. All right. So bye. Thank you. Good night.